The symposium today is being jointly sponsored and presented by the Washburn Law Journal and the Robert J. Dole Center for Law and Government and the Center for Excellence in Advocacy. I should also note that this event has been made possible by generous support from the Robert J. Dole Center for Law and Government's Endowed Fund. We are pleased to bring together a broad variety of scholars and experts today to speak on the issues surrounding law in a post-truth era. For our students, this is an opportunity to understand where the law intersects with politics, policy, and popular thought in modern society. I'm also pleased to report that the Washburn Law Journal will be devoting their next issue to this symposium, and I'm looking forward to reading the articles and essays that will be produced as a result of today's symposium. Today's topic is especially important to lawyers. A primary function of court proceedings is to find the truth. Without judicial findings of fact that generally accord with truth, citizens would over time lose confidence in our adjudicated processes, and they would not regard our courts as an effective means of dispute resolution. So, in general and without more, a legal finding of fact in a court proceeding should accord with the actual truth. And lawyers who work to administer justice must also be truthful. Our ethical rules mandate our candor to the tribunal in both the representation of law and facts. Are we living in a post-truth world where alternative facts replace actual facts and feelings have more weight than evidence? What exactly do we mean by post-truth? Is it wishful thinking, political spin, mass delusion, bold-faced lying, all of the above? Post-truth, I would posit, did not begin with our 2016 election, but it dates back to democracy in ancient times. It's arguably rooted in philosophical debates that argue that there can be no absolute truth. So if we are living in a society where there are no absolute truths, what does that mean for the legal profession where the search for truth is arguably at the heart of what we do? As dean, I don't have any answers. I have only questions. And that's the fun part. I get to sit back and listen to our experts and our speakers today who will be grappling with these questions and will enlighten us. So I want to say to all of you, welcome to Washburn University School of Law. If there's anything that we can do to make your visit more comfortable, please don't hesitate to let us know. And to get us started, I'd like to introduce to you Jeremy Koehler, who is our chief editor of the Washburn Law Journal, and we'll welcome you to our symposium today as well. Thank you.
Thank you, Dean Pratt, and thank you for everyone coming and for all our speakers from across the country joining us. We're so excited to have everyone here. The idea for this symposium actually came originally from a footnote in Professor David Rubenstein's recent article in the Fordham Law Review entitled Immigration Blame. The footnote described the fact that the word post-truth was named Word of the Year in 2016 by Oxford Dictionaries. And we thought the idea of post-truth was a great general topic for a symposium. But as we began researching and looking a little further into this, we noticed symposiums and lectures from across the country talking about post-truth in politics, post-truth in the First Amendment, and post-truth in the press. And we wanted to not only provide something new, but we wanted to provide practical solutions to those in the legal community about how to respond to practicing in a post-truth era. And I think the group we have here today will do a great job of doing that. We'll start off with Professor Strong giving us a further explanation of what post-truth means and what it means to be in a post-truth era. Then we have a panel on jury practice in the post-truth era, moderated by our own Professor Jeff Jackson. Over lunchtime, our lunchtime keynote speaker is Professor Monica Ehrman, and she will discuss how alternative facts impact oil and gas law, which is of huge importance, especially here at Washburn, for the high number of students we have in our renowned oil and gas law program. Finally, our last panel of the day will be on the topic of legal reasoning in the age of alternative facts. And for that, we have an all-star panel of legal writing experts from across the country, and it will be moderated by our own legal writing all-star, Professor Tanya Kowalski. So we're really excited for that. We're really excited to have all of you here and to hear a bunch of great ideas today. Next, we're going to bring up Eric Turner, who will introduce our keynote speaker. Eric is the former editor-in-chief of the Washburn Law Journal. After graduating from Washburn, he clerked for Judge Steve Lieben of the Kansas Court of Appeals, Judge Eric Melgren for the federal judge for the District of Kansas, and Judge Nancy Moritz of the 10th Circuit Court of Appeals. Eric is currently an associate at Foulston Siefkin. Thank you, Eric.
Thank you, Jeremy, Dean Pratt, Professor Leisinger, and thank you to Volume 58, Editorial Board of the Washburn Law Journal for having me here today. As Jeremy said, I was editor-in-chief of Volume 50. You can do the math, how long ago that was. And we didn't even have the courage to attempt a symposium such as this. So I'm really proud of what you guys have done, and I know it takes many people to pull something like this off. I'm particularly interested in today's topic as a former journalist, Washburn alumni, and current litigator. This morning, it's my pleasure to introduce Professor S.I. Strong, Emmanuel Hudson Professor of Law at the University of Missouri School of Law. And I feel like I have one of the most challenging tasks today and try to summarize Professor Strong's impressive academic and professional career into a couple of minutes here. Otherwise, I could spend all of our time reading her CV. The short version is Professor Strong has 4 postgraduate degrees and has more than 100 works published all over the world, in addition to more than 10 years in private practice. As far as education, Professor Strong earned a Bachelor of Arts at the University of Cal Davis, a Master of Professional Writing at the University of Southern California, a law degree at Duke University, where she was the editor-in-chief of the Duke Journal of Comparative and International Law, a Doctor of Philosophy in Law at the University of Cambridge, where she was awarded the Work Prize for Outstanding Doctoral Dissertation, and a PhD at the University of Oxford. As far as private practice, Professor Strong worked at Weil, Gotshal, and Manges in New York and London, where she handled complex commercial litigation in U.S. and English courts, and Baker McKenzie in Chicago, where she practiced in international commercial litigation and arbitration. As far as scholarship, her research areas covers a wide variety, including international dispute resolution, comparative constitutional law, jurisprudence, and the craft of legal writing. She also has been a U.S. Supreme Court Fellow, and for the past 3 years has been a visiting professor in Switzerland, Germany, and Japan. Since 2007, Professor Strong has been at the University of Missouri, where her primary teaching assignments are international commercial arbitration, transnational litigation, comparative law, lawyering, and estates and trusts. In 2017, she published an essay, Alternative Facts in the Post-Truth Society, meeting the challenge, for the Pennsylvania Law Review. In that essay, Professor Strong introduces us to terms that are now part of our modern life. Alternative facts, something that was accidentally coined by Kellyanne Conway in 2017, described as a willingness to persevere with a particular belief, either in complete ignorance of reality or with a total disregard for reality. Post-truth society, where emotions and personal belief matter more than objective facts. Confirmation bias, our propensity to filter out information that contradicts an existing belief in favor of information that confirms that belief. In her essay, Professor Strong notes that traditional methods of pointing out factual inaccuracies by the media or using hard evidence as litigators just doesn't have the same effect as it used to. The way forward may require rethinking not just what we communicate, but how we communicate in this brave new world. And now, with our keynote address, What is Post-Truth and Why Are We in the Post-Truth Era? Professor S.I. Strong.